Seb sent me this link. He said, here's an old one for you. Check out the link from the Attorney General response and tell me if the system is not corrupted. I've never said nor implied that the system is not corrupted. There's corruption at all levels of any government system or any corporate system. If there are people involved in it, there is some level of corruption. Maybe it's people taking a break when they should be working. Maybe it's somebody who takes a pen home from work because they need a new pen. Maybe it's somebody giving a government contract to a friend. You never know, but there is corruption in the system. I've never claimed otherwise. But let's see what we're dealing with here. So check out the link from the Attorney General response. Okay, so let's start first things first. This is the video he links to. In this video, Mr. Hines, it's Travis Hines' video. It's got to be a Travis Hines video. At least it's not a James Freeman video, right? Anyway, so Mr. Hines is sitting in his car in the parking lot of a public library. He's been there for a couple days. This sheriff's deputy, I'm going to refer to him as deputy, comes and does what's called a community caretaking function. Community caretaking function. That's what they call it. When officers are doing community caretaking functions, like if they see somebody broken down on the side of the road, they'll offer them assistance. You know, maybe they won't get out and change a tire, but they'll call a tow company or see if they could push you to a place of safety off the side of the freeway, things like that. It doesn't mean they suspect you of a crime. It means that they suspect you may need help. So the deputy shows up. Mr. Hines gets out of the vehicle without the deputy asking. The deputy is somewhat alarmed by it. He asks to pat down Mr. Hines, and Mr. Hines agrees. And then the deputy proceeds to ask him what he's doing in the parking lot, how long he's been there. Mr. Hines prevaricates slightly and then finally agrees that he has been there for 2 days. The officer then asks Mr. Hines for his ID. Now, why might the officer ask Mr. Hines for his ID? Well, as part of his community caretaking function, he's initiated contact with Mr. Hines to see if he's okay, to see if everything's all right, to see if Mr. Hines needs assistance. Well, Mr. Hines was behind the seat of a vehicle. There is a vehicle involved. Mr. Hines either drove it there or will drive it away from there at some point in time. Mr. Hines is in control of the vehicle, so according to State v. Martinez, this is a Court of Appeals case from Idaho. It does appear very strong that the officer was allowed under state law, and there's no objection from the Fourth Amendment that anybody has put forth in any of these, or no winning argument from the Fourth Amendment on any of these. So in this particular case, in State v. Martinez, there was a car broken down on the side of the road. The police officer made contact with the driver, asked the driver if he wanted the officer to push him to a gas station. While the push was going along, the officer ran the plate. There was a clerical error. There was some just transposed number. But it led to a series of events that found drugs in the car. Dog sniff, drugs. And the court said that that's A-OK. The court references Godwin v. State. This is an Idaho Supreme Court case where the state troopers pulled over one car. The friend, Godwin, in a second car, pulled over to wait for his friend to get a ticket so they could be on their way. Another officer asked Mr. Godwin for his license. Turns out Mr. Godwin's license was suspended, and the Idaho Supreme Court said that was A-OK. The Idaho Supreme Court in Godwin cited State v. Ellenbecker, where an officer who asks a motorist if they need assistance and the motorist says they don't need assistance, the officer can still demand the driver's license and conduct a status check at the scene. Long story short, the officer could demand Mr. Hines's license. Mr. Hines took exception to the report of the officer. The report is accurate enough. I mean, the officer doesn't have a recording. The officer didn't turn on his emergency lights, which would have activated his recording system, because the officer was there on a community caretaking function. He wasn't there in a criminal capacity. And had Mr. Hines offered his license when demanded, then Mr. Hines would never have been arrested, and it never would have shifted from a community caretaking function into a criminal investigation or an arrest. So there you go. So was the report inaccurate? You can read it. It was accurate enough for me. I would have a difficult time trying to impeach the officer if the officer relayed this to me in court, having not viewed the video. The time passed between the time this interaction happened and when the officer wrote this report. It's natural that some things aren't going to be accurate. You going back over the video and finding niggling little details doesn't mean the officer was lying. It means he misremembered a few things. They weren't crucial details. They weren't even important to whether or not Mr. Hines had obstructed the officer. So there you go. Now we're about to get to the Attorney General letter. This is the statute it's based on, 31-2002. Mr. Hines complained to the sheriff about the deputy. The sheriff declined to act on the complaint. Whether or not there was an investigation, I don't know. You don't know. Nobody knows except for the sheriff. So the sheriff did not discipline the officer, did not act on the complaint. I don't think the deputy did anything wrong, but whatever. So Mr. Hines wrote a complaint to the Attorney General about the sheriff not acting on the complaint about the deputy. Yes, it's a little convoluted, but Mr. Hines' complaint to the Attorney General was based on 31-2002, investigations and actions against county elected officers. It's a county elected officers. Sheriffs are elected, deputies aren't, so it's against the sheriff. Duties of Attorney General. Notwithstanding any provision of law to the contrary, the Attorney General may conduct an investigation of any allegation of a violation of state criminal law against a county officer occupying an elective office for a violation of state criminal law in his official capacity. So if an elected official violates state criminal law in his official capacity, that's when the Attorney General will start their investigation, and they will either issue a finding of no further action necessary, they will suggest training or other non-judicial remedies, or they will determine further investigation or prosecution is warranted and retain the matter and act as special prosecutor. So those are the three options. What happens is they go through it and they figure out that though you may disagree, so they don't think that Hines's complaint regarding the deputy sheriff or the sheriff failing to act on that complaint, they don't think that amounts to a criminal violation of Idaho code, and it does not. Though you may disagree with the actions of the Boise County Sheriff, Idaho Code Section 31-2002 does not authorize the Attorney General to investigate acts of a public official that the complaining party considers inadequate performance of duties. And that is 100% in accordance with my understanding of it. There is no evidence that there was any corruption in that at all. The deputy appeared to act reasonably in this situation. His report was reasonably accurate. The sheriff was reasonable in not pursuing any actions against the deputy. And the Idaho Attorney General was reasonable in its interpretation of 31-2002, which does not authorize them to act against the sheriff for failing to act against the deputy on a complaint. That's really confusing and convoluted, but there you go. So sorry, Seb. I don't think you're proving what you think you were proving. I do appreciate the interaction. It was a mildly interesting video to watch. Mr. Hines, I hope he gets help. Thanks for watching. Have a great day.